Hi, Jeannie. How are you?
Good morning. How are you?
I'm doing well, thank you. So introduce yourself. Tell us, what the mediation committee is about, a little bit of who's on it and how these people have gone and joined your committee.
So my name is Jeannie Wheat. I have been the mediation chair for 8 years. I served on grievance prior to that and as a mediator on the committee before I took over as chair. The mediation committee is basically a select group of realtors who have requested to be on the committee, but the choice for them to be on is up to myself, and this year we now have vice chairs. So the vice chair, and we look at their credentials whenever they fill out, the committee request forms in the fall. They have to specifically answer a few questions to be on this. We've recently put a task force together with Pro Standards, Grievance, and Mediation to determine the requirements moving forward for mediation. That's being presented to the board and at the next board of directors meeting. And then once that's adopted, when those committee selection forms go out, it will be on that. It references training and education and things like that.
Okay. And so, being on this committee, when does your phone basically ring, or when do you get that email? When do you get that first call?
Chris calls me. He'll send me an email and says he will say we have a request to mediate. And then it goes through the process. So whereas grievance only sees the complaint, as mediation chair, I see both. I see the complaint and the response because we have to make sure that there are no conflicts of interest with anyone that is involved for the mediator that is going to be assigned. So in years past, it was a very small committee, but as the board grows and we see more complaints, we have decided to make the committee larger because we want to make sure that we have an ample group of mediators to work with where there is no conflict of interest. And as Ellen was, mentioning before, you don't want to have 5 mediators all from the same office. So we have diversified the group. We've made sure that, we're Monmouth County, Ocean County, and multiple offices are represented on our committee.
Okay. And so how does it work? So once it gets in your hands, what's the process?
So mediation is actually the preferred form, preferred way to resolve any disputes between realtors, and even now between, with the public as well. And it's not just our board, it is NAR and NJR. It is the preferred way to resolve disputes. So there's some paperwork that needs to be filed. Once the agreement to mediate comes through, then they have to agree to the mediator. And Chris sends that document out. And then everyone has, a couple of days to respond and say, yes, we're okay with that. Then once that comes back, then we set a day and time. Now, the most recent ones obviously were Zoom, but now that we have, been back in person, really the preferred way to mediate is when everyone is in the room together. Because that's really what it's all about. It's about bringing the parties together and trying to like a collaborative effort with both parties to resolve the dispute and promote an amicable resolution. And it's so much easier to do that in person than it is to sort of do on a screen like this. So that's the beginning part, to get to the mediation. Then how it works is the mediator reads both the complaint and the response, and they are not allowed to make any determinations or any decisions. They have to be completely unbiased. Their role is basically to open up a conversation between the two parties, and try to get that conversation to a point where the parties agree, you know what, this, maybe I did a little bit wrong over here, you did a little bit wrong over there, and let's figure out a way that we can resolve this and make it mutually agreeable for everyone that's sitting in the room.
Okay, and is that, so that would be basically what the benefit would be, is that both parties can walk away satisfied?
Yes.
As opposed to going through the process of.
If you leave mediation without coming to a resolution, you are going to go to a hearing panel. And when you're at a hearing panel, one person will come out as for lack of a better word, winner and losers. Someone will win that arbitration or that hearing panel, and someone will not. With mediation, everybody walks away with something, whatever it is. Typically, we are involved in arbitration. It's money, and that's usually what it is. However, in the last year and a half, we have been seeing some ethical violations, which we are allowed to mediate as well. And we did one this year successfully. It was an advertising issue. And so there's no money being resolved, but at least the parties all agree that, there was, some discretion that was a violation of advertising, and, it sort of was brought to the forefront, and it was resolved. If you leave mediation and don't resolve it, you are leaving that decision to a panel, to the hearing panel. Whereas when you're in mediation, you make that decision. Both parties can come to that decision together. The goal for the mediators to try to get the parties to come up with their own resolution. We don't like to say, well, what about? But if we find that it's getting a little, it doesn't look like it's going to come to a resolution, then we can sort of say, okay, well, what about if we did this? How would you feel about if this is how we resolve this issue? And fortunately, in the 8 years that I've been doing this, we've only had one unsuccessful mediation. Now, typically we only see 2 or 3 in a year. This year we've already had 3. So moving forward, we'll see what happens with that.
Both parties have to agree to mediation in order to.
Yes, both parties have to agree to mediate. They can get up in the middle of the mediation and walk out and say, I'm not doing this. They can leave. We try to not let that happen, which is one of the reasons that it's really, really important to be in person, because what we can do is sort of separate the parties and let them sort of simmer down, talk to their brokers, sort of have a little bit of a think on it, and then bring them back together. Whereas when you're on a Zoom screen and you have to put somebody out into, a break room and then bring everybody back, it's not as conducive to opening up the conversation. And that's really what mediation is all about. Bringing that conversation out, letting everybody sort of air their grievance, so to speak, and then support, whatever accusations have been made against them. And you'd be amazed, like once you start having that conversation, people really sort of figure it out. They're like, you know what? Yeah, I got it, and, to Tricia's point earlier with the ombudsman, sometimes people just need to vent, like they just need to get it out. And mediation sort of allows them to do that. And then as a mediator, you try to figure out a way to, okay, now you vented, now you've, said what you needed to say. Let's figure out a way to bring this all back together.
Does the public ever get involved in mediation?
They can. We haven't had one in 8 years. We have not, but they can.
Does an attorney ever get involved with the realtor when you're doing mediation?
You can certainly bring an attorney with you. You can bring witnesses. We had one recently that had witnesses, but really it's a conversation between the two parties. Bringing an attorney with you, it's, what is he going to do? Present the facts for you? And he can ask questions, but not in a sort of, attorney format, like in a hearing. This is a conversation. This is not a hearing. So you bring an attorney in and then he starts sort of, has accusations against the respondent. That doesn't always bode so well. And it's just easier and less complex if it's just the parties involved. And that is the other thing. We had one recently where the agent who filed the complaint wasn't at the mediation. I would strongly not encourage that. The person that filed the complaint should absolutely be there. Obviously, the broker is the one who makes the final decisions, but you'd be surprised when you're in a room and you start having a conversation, the person who filed the complaint says, you know what, let's back off on that a little bit. If that person isn't there to engage in that, and you're just dealing with the broker is going to take a stance and say, no, this is what my agent wants. If the agent is in the room, they can change their mind.
And if once the outcome, is it binding?
Yes. So at the end of the mediation, you sign a resolution. Everyone has to sign it. And there's a time and a date and all of that where if it's money, it has to be, sent and delivered. And then everything gets filed. If one of the parties fails to perform the resolution, then you don't even have an option to go to professional standards. If you do not do what you have agreed to do, then you have to take that to a court of jurisdiction, and then we're out. We are completely out. So make sure that when you sign that resolution and you come to that agreement, that you are going to perform that agreement that you have agreed to.
So what if they walk away from mediation and they say they want to move forward? Are they done with mediation, or can they go back to mediation?
No, they can go. They can be literally sitting for an hour and a half in a hearing panel and say, oh,
when
wait
you
a minute.
Hearing panel, you mean like if it moved up to professional standards?
Yes, if it goes up to professional standards, yes.
So they say, I don't want to do mediation. I'm done. Then we're not going to work this out. I want to go to professional standards. They go through that whole process.
Yep.
And somebody regrets their decision. What can happen?
They can come back and agree to mediate.
Excellent. Good to know. Yes. That they can
mediate. They can walk out of that. You can agree to mediate at any time. You can also walk out and not agree to mediate during the mediation, but you can agree to mediate at any time. Now, anything that was discussed during the mediation as far as financial compensation cannot be brought to a pro standards hearing. That information cannot be passed along. Any of the evidence can absolutely be passed along, but any resolutions that were discussed or possibly, almost agreed to, that cannot be discussed after mediation. Everything in mediation is confidential. And you cannot use any of that information moving forward. You're actually going to have to start from scratch and start all over again.
So if I understand everything you said, basically both parties have to agree to mediate. You can mediate at any time. You could go back and mediate if you didn't think you wanted to, and you can also leave mediation at any point. Both realtors and the public can choose to mediate. You can have an attorney, but you don't see the necessity in it if you're trying to actually avoid conflict, is what it sounds like you were saying, if I'm not putting words in your mouth. And it's basically a resolution that both parties could walk away possibly feeling satisfied, whereas if it goes to professional standards, which we're going to now go to if we don't have any Q&A, I'm going to have Anna check the Q&A. if, whereas a professional standards, one person's going to leave feeling satisfied and the other person's going to be very unsatisfied. So, so it might be in everybody's best interest to try mediation, because somebody, both parties could walk away happily.
Yes, absolutely. And to my point earlier, where it is a preferred method for resolving disputes, something that the state initiated about a year ago that is new is what they call the mentor program. Because mediation is not an easy thing to do. You sit in a room with people that are, they have a dispute over something, and when it's money, that's usually, they have a strong stance on what they feel they're entitled to.
So a perfect example, can I just interrupt you? So you were saying, so let's just say it's a commission, somebody thinks that they had procuring cause, for example, and you bring them into mediation. What you're saying is that in professional standards, one person is going to win the procuring cause and the other person is going to walk away with a zero commission. In mediation, you can agree to say, I'll give you a referral of X amount, or we can split this commission in this way, where both parties could possibly even get paid in a mediation, or not, depending upon what they agree to. But is that would be a situation where both parties are at least feel like they got something out of the situation, whereas in professional standards, one person's getting paid and one person is not.
Yeah, typically mediation is a win-win for both parties. One of my favorite expressions is like, a piece of the pie is better than none of the pie. And like I said, 8 years with only one that moved on. That's a pretty good track record. But the mentor program is allowing strong mediators to sit in on a mediation and sort of oversee it as we're moving forward into, some more degrees of complaints that are just beyond some of the norm that we've seen over the last, few years. Which is a great program. I love that they're doing that.
Wonderful. Thank you so much, Jean. Anna, do we have any questions we want to address before we go on to the next topic?
Yep, I'm going to jump in. I'm going to ask Chris to just touch a little bit on when we get involved, we don't get involved with commissions between a broker and their agent. So if you could just kind of clarify that and make sure everybody understands that part.
Yeah, so essentially, we don't get involved when it's a conflict between a broker and their agent, because essentially that's going to be an employment dispute. That's not what we do. What we do when it comes to that is going to be like broker to broker. Obviously, when commissions are involved, it's got to be one brokerage against another. It can't be a brokerage and their agent, because that gets into too many things, and that you can contact the governmental agency and get that taken care of. That's not for us, especially when it comes to commissions, because that is between them and the broker. The board cannot get involved when it comes to that. We just can't do it.
Okay. I know we have a couple of questions in here. Some of them I'm going to save for the Q&A at the end so that we have all of our panelists on for it. But I do just want to clarify, Chris, if you could just kind of point out. So this is kind of a threefold question here, but can you just clarify for us who is actually supposed to be filing a complaint? So is the realtor filing a complaint, or does the broker always have to file the complaint on behalf of a realtor in their office?
So if it's ethical, anyone can file that complaint. It doesn't matter who it is. It could be, as I said, it was a member of the public, a realtor, the broker, doesn't matter. When it comes to arbitration, the broker ultimately has to file, but that doesn't mean that the realtor can't be involved. Their agent can be involved in that, and they can go throughout the entire process, but ultimately the broker has to be there because they are the deciding factor, right? So that's just how that is, but that's for arbitration, not for ethics. So ethics, of course, anyone can file.
So what is it? Because I think this is a good question. What happens, or what are a realtor's rights if their broker says, we have a financial complaint, arbitration complaint, and my broker doesn't want to get involved and help me file a complaint on this, but I feel like I have a really valid case here. So then what happens? What rights does that realtor have?
Yeah, ultimately, if their broker does not want to get involved when it comes to arbitration, they essentially can't move forward with filing with the board. They may be able to seek that out in other courses of action, but unless they have their broker behind them, we cannot move forward with an arbitration request.
Okay. And then we also have the question of, is there, I think Suzanne touched on it, but is there an amount of time allowed between the infraction and the complaint itself?
Yeah. So essentially, when you have 180 days to file a complaint with the board, that's your due process, if you will. So if it's from when you notice, essentially when this happened. So if, let's say this happened back in 2020 and it's 2022 and you're trying to, file a complaint with the board, we can't accept that because you didn't do your due diligence and file within the 180 days of noticing what was taking place. But if it was done within 170 days, that's still within that time frame, so you can file a complaint with the board.
Excellent. So just last question before we bring Tricia back on is evidence. So Jeannie, you had mentioned about, what happens with mediation and then if it goes to pro standards. So the question is, can evidence be brought to the pro standards hearing if the source was mediation, or can it not be brought to?
No.
Okay.
No, anything that's disclosed during the course of the mediation needs to be, it's all confidential, and we're actually supposed to shred everything that comes out of that. You're not allowed to introduce something that came out during a mediation. You have to stick to the original complaint that was filed. And that's what then goes back to professional standards.
Okay, and I'm sure Tricia will touch more on what they're looking for in professional standards. So with that, I'm going to thank Jean for all of her information, and we're going to bring Tricia on.